So welcome everyone. I hope you've been enjoying the Housing Expo this first time to do it virtually. And I'm going to miss having that interaction person to person, but we're going to live with it like everything else with COVID, right? So we're going to be doing this workshop today, and we call this a boot camp because it is pretty much just an introductory to your rights. The San Francisco Tenants Union, by the way, didn't introduce myself. My name is Layla. I am a tenant advocate at the San Francisco Tenants Union. And we actually publish a book of tenant rights, and it's about 350 plus pages. So as you can guess, we're not going to be covering all of that today. So this is going to be just a little taste, a boot camp, just an introduction to tenant rights. Everyone's going to be muted during the presentation, so we're asking you to please hold your questions to the end, and you'll be able to type those into the chat. And if you have any technical difficulties, just type those into the chat also, and someone will be taking care of that. So we're going to get started. Why is it that tenants lose their homes in San Francisco? What's the number one reason? When asked this, people often say, it's probably an owner move-in, that nasty Ellis Act, that state law that San Francisco can't overturn. But the fact is, the number one reason that tenants lose their homes in San Francisco is actually not knowing their rights. It's amazing the number of people who simply walk away from their tenancies because the landlord says they have to, or because the landlord intimidates them into thinking they have to leave. So that's why it's very important to know what your rights are. So we're going to go over some of the basic things that a landlord actually has an obligation to provide. The landlord must give you 24 hours written notice to enter your home, except in emergencies. What would constitute an emergency would be like flooding, an electrical safety issue, which could spark a fire. What is not an emergency is the landlord telling you, well, the plumber was scheduled to come next week, but he's here today, so I'm just going to go ahead and give him access to your apartment now. That's not an emergency, and you would not have to give access. Landlords must provide you with a habitable home, and they must make necessary repairs. The landlord must give you a copy of your lease if you request it in writing. If you've lost your lease, don't worry. You don't have an obligation to keep it, although it's a good idea to do so. But once a year, as long as you don't request it more than once every 12 months, you can ask your landlord to send you a copy. Just you have to do it in writing. And the landlord has an absolute obligation to provide that. Things that your landlord can't do. Your landlord cannot lock you out of your home. And that is even if you haven't paid rent in the past year. Landlords are not allowed to lock you out of your home under any circumstances. If there should be a judgment against you and the sheriff should show up with a writ of possession, that could happen, but not by the landlord and not by the police. The landlord cannot evict or raise your rent without written notice. There is no such thing as a verbal eviction or a verbal rent increase. The landlord cannot charge punitive late fees. Can the landlord charge you $25 because you paid your rent late? Sure, that's a reasonable amount of damage. They probably could get away with that. Can your landlord charge you $150 because you didn't pay your rent on time? That would be a punitive late fee and would not be allowed, even if it's in your lease, even if you signed that agreement. Landlords cannot require you to pay rent by cash or online. If you choose to pay by cash or online, that would be your choice. If you do pay by cash, under no circumstances do you hand over cash in one hand without getting that receipt in the other hand. You have to have proof. And if you choose to pay online, that's fine. Always pay in some way that you can actually trace your payments. So here in San Francisco, we have the rent ordinance. And the key San Francisco rent control rights consist of two arms of that rent ordinance. And I always say you want to get like a double hug. You want both those arms wrapped around you, keeping you secure. This year, rent increases are capped at 0.7%. That began, I should say, March 1, and it continues through the end of February next year. So that's one arm, the rent control arm. The other arm of the rent ordinance says that you cannot be evicted without just cause. So you have both of those protecting you if you're fully covered by the rent ordinance. How do I know if I'm covered by the rent ordinance? Well, one thing you can do is you can call the rent board, 415-252-4602, and you can give them your address and they'll let you know if you're covered by the rent ordinance. But in general, the rent ordinance covers all properties except property that was built after June 1979. It does not cover condominiums. It does not cover single-family homes. Those are exempted. Government owned or subsidized, also not covered. There are a few other exceptions like dormitories or public housing, but for the most part, that's a lot of it. The difference is if you live in a single family home with an in-law unit, and it doesn't matter if that in-law unit is legal or not, a single family home with an in-law on the same parcel is covered by the rent ordinance, because at that point, it is not a single family home. It is actually a 2-unit property. The other arm of the rent ordinance, just causes for eviction. In San Francisco, there are 16 just causes for eviction. The most common include the following: not paying your rent. Another one is not paying your rent on time. A lot of tenants don't realize that just because your rental agreement says that rent's due on the 1st and you don't have a late charge until possibly the 3rd or the 5th. Sometimes tenants will say, no, I've never paid my rent late. I always pay by the 3rd. There's a difference between getting a late charge and paying your rent late. You don't want to fall into this trap. If your rental agreement says it's due on the 1st, that's the day the rent's due. Whether or not you've never incurred a late charge doesn't mean that you haven't paid rent late. And it only takes a few of these per year for you to get into trouble. So make sure you not only pay your rent, but you pay it on time. Another common thing is violating the lease agreement. You know, pet clauses, number of roommates, whatever. Nuisance. We're seeing a lot of landlords trying to charge nuisance right now. Nuisance basically means interfering with the quiet enjoyment of the premises of others. Now, those are fault reasons that you could be evicted. And there are 2 on this list that are actually no fault: owner move-in and Ellis Act. And probably a great number of you have heard about both of those. So breach of lease and nuisance, these are what we call gotcha evictions. Breach of lease, there's a restriction on the number of roommates. By the way, not what's on your lease, but what the housing code says. So your lease could say that you can only have 2 people living in your apartment. If the housing code says different, then we would go by the housing code. Saying that you cannot have pets and you have a pet. Making unauthorized improvements. This is why you have to read your lease. A lot of tenants don't know that if there is a clause in your lease that says that you cannot do any repairs without the express written permission of the landlord, no matter how much you improve that property, the landlord actually could say that you're in breach of lease for doing those repairs without permission. Nuisance. Nuisance is substantial interference with the comfort, safety, or enjoyment of the landlord or other tenants in the building. No 3 a.m. parties, no harassing neighbors. These are things that fall under nuisance. Now, these gotcha evictions, nuisance and breach of lease, were really getting out of control. And there was significant tenant legislation that the Board of Supervisors passed back in 2015 that helped stop some of these gotcha evictions that were impacting tenants. This legislation says there must be a chance to cure minor offenses. And if you're going to charge someone with a nuisance eviction, it's going to require proof. There is no eviction for adding a roommate if the landlord unreasonably refuses. There's a 7-step procedure that you follow for adding a roommate, and as long as it doesn't exceed 2 persons in a studio, 3 persons in a 1-bedroom, 4 persons in a 2-bedroom, and 6 persons in a 3-bedroom, and up with 2 persons per bedroom. The landlord would probably be considered unreasonable for refusing to allow you to add those roommates. Sorry. One moment, just have to take a real quick sip here And lastly, rents can actually be regulated when there's a no-fault eviction. So while usually there's a allowance of raising the rent to market rate after vacate, if one of these evictions takes place, it could actually continue to make that rent regulated. Owner move-in evictions. Okay. There are lots of regulations around owner move-in evictions in San Francisco. And back in 2017, it was necessary to actually strengthen the enforcement of some of these rules. If you were to be served with an owner move-in eviction notice, you would get a minimum of 60 days notice. You would be eligible for relocation payments. There are protected tenants, and for an owner move-in, a senior is considered anyone over the age of 60 who's lived in the building for 10 years or more, disabled, or catastrophically ill. There's only one owner move-in per building, but if the landlord lives there, they can move in relatives into the other units. And they can also do that if they're all moving in at the same time. One of the great protections we now have, though, is there is no owner move-in during the school year for school workers or families with children of any age. The children do not have to be of school age, and you don't have to be a teacher. It could be anyone who works at the school. The Ellis Act. Ellis Act evictions. So this is a state law that allows landlords to go out of business and not be in the rental business any longer. If you're threatened with an Ellis Act eviction, if your landlord says, if you don't take this buyout, I'm going to do an Ellis Act on you. We call that the Ellis threat. So if you're threatened with eviction, you should get help, act immediately, and organize. Smaller buildings are at the highest risk. So if you live in like a 2, 3, or 4 unit building, those are the ones that are at highest risk for this. You would get a minimum of 120 days notice if you were served with an Ellis Act. And if you're a senior, and in this case, senior means 62 or above, or disabled, you would get 1 year's notice. And once again, relocation payments are mandated. Most important with the Ellis Act, get help. It could be a bluff, it could be illegal. Act immediately. The deadlines for getting extensions for that 1 year notice for being senior or disabled could go away. So you have to get on top of this paperwork as soon as it's served to you. There's power in numbers. Everybody in your building is going to be affected by an Ellis Act because you cannot Ellis Act a single unit. It means the whole building will be cleared. So this is the time to get to know your neighbors and decide to fight together. Now, the relocation payments that were mentioned for both the owner move-in and the Ellis Act, they vary slightly, but it's only a matter of a few dollars. So I'm showing here the amount of mandatory relocation payments for the no-fault evictions under the owner move-in law. Ellis Act would be slightly different. So each occupant, up to 3 occupants in one tenancy, you would get $7,414 per occupant. It maxes out at $22,240 per rental unit. If you're a senior, disabled, or if your household has a minor child, you would get $4,943 additional for each of those. Now, make note, children are considered occupants also, so that would be a bonus payment with an owner move-in. With an Ellis Act, you don't get the extra bonus payment, but the child does count as an occupant. Now, these are minimum payments. The law requires these if these particular types of no-fault evictions are being pursued. But tenants can negotiate for more time and money. So how do you protect yourself from eviction? First of all, read your lease. Make sure that if you have any provisions in that lease and you haven't looked at it for a while, you could forget. There are some restrictions in there. So keep a copy of your lease. If you don't have one, request it from your landlord and make sure you read it thoroughly and you know what you're agreeing to. Get any kind of informal agreements in writing. I don't care how great your relationship is with your landlord, that landlord may not own the building next year. So any kind of informal agreements, oh sure, get a pet. I know you've got a no pet clause, but you can get a pet. Oh sure, go ahead and park your motorcycle in the driveway. So these things need to be nailed down in writing. So if you don't feel comfortable making it so formal with that great landlord you get along with, you can simply write a thank you note and say, thank you for agreeing to let me do the following things. But most important, you need to document it in some way. If your building's for sale, beware. This is when things often change for tenants. You can have a really great landlord. You might even be like me and you had 2 great landlords in a row, but then that third one, that was a very different scenario. So when their ownership changes, just remember, listen a lot. Don't talk about your plans. Know that this person is someone that you're going to have to vet before you start to trust them completely. And maybe you'll never trust them completely. And don't just leave. Don't let anyone tell you, oh, I'm buying the building, you have to leave. Oh, I'm doing this, you're going to have to move out. Never just leave. Learn your rights, get help, and then decide what your next action shall be. So, San Francisco passed a very historic measure back in June 2018. Hundreds of volunteers and tenant rights groups worked on this. And this has been a real game changer, even before COVID. So San Francisco tenants now have the right to a free, full scope attorney to fight their eviction. That unlevel playing field with the landlords having all the money and being able to hire attorneys, that's been leveled a little bit with this law. There are exceptions. It does not apply to evictions that are conducted by a roommate or an owner who lives in the same unit with you. So roommates can't they can't try to evict roommates and apply for the right to counsel, nor can you apply for this if you live in the same unit with the owner landlord. It's important anytime you're facing an eviction or the threat of eviction to act quickly, because you can be displaced by fraudulent evictions, even if they are fraudulent, if you don't respond. Now, in addition to this COVID-19 Tenant Relief Act, I just want to make mention when we're talking about evictions, we currently have moratoriums against evictions. So no eviction can really go forward right now unless it is a threat to bodily harm, there's been domestic violence, or there's a health or safety issue. So we're currently operating under a moratorium, so you can relax a little bit on that whole subject of evictions for now. But what if you can't pay your rent? So the COVID-19 Tenant Relief Act, there's so many thousands and thousands of tenants that cannot pay their rent. The coronavirus has just devastated the rental market. So what do you do? Well, the good news is that there is some protection built in. If you've had decreased income, whether that's loss of a job completely or just decreased hours, if you've had increased expenses, perhaps you're an essential worker, maybe you stayed at a hotel so that you wouldn't go home to contaminate your family, that would be an increased expense due to COVID-19. If you've had health impacts or excessive medical bills because of COVID-19, family care, where you had to care for a child or care for an elderly relative. Anything that's impacted your income, decreased it, or you've had increased expenses due to COVID-19, then you can apply for this protection. The most important thing to remember is you can never be evicted, ever, for failure to make rental payments from March 2020 all the way through June 30th of this year. Now, currently the expiration is June 30th. We also had an expiration at the end of January and it got renewed. So there's a good possibility that this will get, renewed at the end of June, but we can't count on it. So for right now, it goes all the way through June 30th. So how do you get these protections? Well, one is there's a declaration that you're going to need to sign. If your landlord serves you with a 15-day notice to cure or quit, in other words, a 15-day notice to pay rent or quit, you must answer by signing this declaration that's sworn under penalty of perjury. If you sign this declaration and send it to your landlord, it cures that notice. In other words, that notice goes away. The second thing is that there's going to be some rent due between the months of September 2020 and June 2021. For those particular months, 25% of your rental payment is due by June 30th, 2021. You can make those payments in multiple payments, or you can make it as just one lump sum payment as long as it's paid before June 30th, 2021. So sadly, yes, the good news is you can't be evicted. The bad news is then now you've got this debt. This debt is like any other consumer debt. It's like a credit card that you didn't pay, but you can never be evicted for it. So even though tenants are relieved they can't be evicted, they're concerned about facing that debt. Well, the good news is that there are rental assistance programs that are going to be there to hopefully help you pay off that debt. We have not only local funds, which thanks to all the tenants and landlords and everyone else in San Francisco that voted for Prop I last year, we have local funds available. And that particular fund, which taxes property sales of 10 million or more, is actually generated even more income than we anticipated. We're also having money come from the federal government. The state of California is getting $2.6 billion to go toward rental relief, which sadly is not enough to pay off all the rental debt. But the great advantage in San Francisco is we actually will have access to both sources of funds, both our local Prop I funds and those federal funds coming via the state. So getting repairs. Lots of requests for repairs right now coming in from tenants. And there is a provision, and a lot of people ask, well, can I withhold rent to try to force the landlord to make the repairs? Yes, there's a provision in the law to do that. We recommend that you almost never go this option. Don't withhold rent. There are much better options. The first thing you should do is you should write a letter to the landlord and do this with a proof of mailing. Doesn't need to be certified and probably shouldn't be certified. Proof of mailing, there's nothing on the outside of the envelope. The landlord doesn't know that you've got a receipt from the date that you mailed it. You can also add to that delivery confirmation. That doesn't require a signature from the landlord, but you will get a receipt from the postal person saying what day they delivered it to the landlord. So first you write a letter to the landlord. The landlord can't fix things that they aren't aware of. So you've got to do this in writing and give them enough time to address the repairs. If they don't, then move to step 2. Make a complaint to the Department of Building Inspection, the Housing Inspection Services. That number is 628-652-3700. The Department of Building Inspection will come out and they will make the landlord a list of all the things that you have pointed out that they say need to be repaired. They also will notice a lot of other things possibly that you didn't notice or didn't care about. So landlords are really much better off answering their tenants' requests for repairs because it's much better if the Department of Building Inspection doesn't show up. You should get a copy of the report. So be sure and ask the inspector, when do you think you'll have your report ready? Because I think I might need that going forward. Lastly, you can go to the rent board and file a petition. File a decrease in services petition for every day that you didn't have use of that shower, every day that you didn't have use of that broken down refrigerator. Those are all things that you contracted for when you signed your lease. And if they've been taken away, then the amount you're paying for your lease is not a fair amount. So you can file a petition at the rent board for a decrease in services, or sometimes that does maybe get escalated to a lawsuit, but you should definitely get advice about that. Sometimes people say, whoa, I hesitate to rock the boat. I'm concerned that if I ask for repairs, my landlord will, retaliate against me. Well, it's not that we can guarantee the landlord might not retaliate, but the landlord cannot legally retaliate against you. The landlord cannot terminate your tenancy, can't raise your rent, can't change the terms of your agreement just because you complained about housing conditions. It's very important. Make your complaints in writing. Even if you've had a conversation with the landlord, go back and do a recap. Say, hey, this is what we discussed today. This is what we decided upon. Just wanted to, do a memorialization of our conversation. So it's most important, as you can see many times, you must get things in writing. So assert your rights in a way you can prove. Keep journals. When you've got a difficult landlord, one of the best things you can do is start keeping a journal of everything that they say or do. And you never know, someday you might think it's not important. Some of their statements actually might have some significance later on. So what do you do if you're not covered by the San Francisco rent ordinance? Well, it used to be you were almost out of luck for pretty much everything because California does not have a lot of protections against both just causes or rent ceilings. That changed. In 2019, California passed the Tenant Protection Act. So if you are not covered by a local ordinance and you live in a building that's over 15 years old, so that would be pre-2006, you're now covered under the California rent control. There are exemptions. So if you live in a 2-unit building and the landlord lives in the other unit and they've been there the full time that you've been living there, lived there continuously, then that unit would be exempted from the state rent control. There are also exemptions for single-family homes that are owned by an individual, but not those that are owned by a corporation or a real estate investment trust, or even an LLC that has a corporate partner. So provided that you live in a single-family home owned by an individual, if they give you the proper disclosure notice, that also could be exempted from rent control. There are additional exemptions for lodgers. A lodger is when a single person lives in the same unit with the landlord, and properties with in-law units. So as you can see, this isn't as good as San Francisco's rent control, but it was certainly better than what people had before that could not rely on the San Francisco rent ordinance to protect them. So the rent ceiling protection in California, if you're not covered by a local ordinance, is 5% plus the consumer price index. Remember I said San Francisco's rent control this year, 0.7%. If you're getting ready to change apartments, you just might want to try and make sure you get one that's fully covered by the rent ordinance. There are also eviction protections at the state level. Those kick in if all the adult tenants that live there have lived there for more than 12 months, and if all the adults that live there have not lived there for more than 12 months, if there's at least one tenant that's lived there for 24 months, then you would be covered by the California rent control. So how do you fight back? Number one, you do kind of what you're doing today. You get started with the basics. You learn your rights. You can't fight back if you don't know what your rights are. 2, you have to assert your rights. It's not always going to be easy, but there are going to be times that it may seem uncomfortable. but those persons who fight back actually probably get bullied a lot less than the persons who don't fight back against the landlord. So sometimes you're going to have to assert your rights. Get involved. You know, it's like when I talk about this legislation that we've passed to protect tenants, we did that with the tenants out on the street, talking to their neighbors, maybe joining a campaign, but stay involved. And that way, that's one of the ways you can fight back. So you can join the San Francisco Tenants Union. We like to organize people. You can organize your building, your block, your neighbor. As I said, if you're facing an Ellis Act, you might want to get that building organized, fight back together. It may be necessary that the whole block and neighborhood fights back if we've got some pending legislation. And once again, support legislation to stop displacement. Always know what you're voting for. Look to see what organizations are endorsing legislation to stop displacement. Because there were numerous times in this presentation that the reason that we have protections is indeed because the tenants supported that legislation. So that's the end of our very brief overview of some of your rights. So for those of you who have questions, we're here to answer those questions. So I'm going to flip this over and let the technical support person tell me what to do next in terms of getting your questions answered.
All right, thank you so much, Layla. So yeah, we have a few questions. If anyone else has any other questions, please just put them in the chat. The first question was, I only have one way in and out of my apartment. Is that legal?
No. One of the requirements for an apartment to be legal is to have at least two entryways, exits, shall we say. And one of the ways you can find out without filing a complaint or calling attention to it, because no other agency in San Francisco cares about an illegal apartment. They're not, but the Department of Building Inspection are the ones that are responsible for deciding what's to be done with those. They don't want to see them. They don't want to take them off the market. So you could check with the Department of Building Inspection at that number I gave you earlier, and you can give them your address and they can actually look up. There's also a way to look it up online. If you go to sfassessor.org, that's SF in San Francisco .assessor, as in assessor recorder.org, and you go to property search, and then you go to access, you can actually type in your address. So if you live in a 4-unit building and it only shows 3 units and you kind of think yours is illegal, there's your confirmation, because the city doesn't recognize illegal units on the assessor site.
Okay, great. So one question that came in is, I wanted to understand how the moratorium SB 91 affects subtenants and master tenants differently. If so, and what people can do about it.
Well, it sort of depends on the situation, but an example would be perhaps the master tenant has not had their own personal income impacted in terms of maybe they still have their job and it still pays them the same amount, but they were counting on that income from their subtenant. So they have been impacted, because a master tenant, when they're in that role of master tenant, is actually the landlord to the subtenants. So that income that they were counting on getting from those subtenants who may have lost their job does indeed impact their ability to pay the rent in full. So that's one way that master tenants and subtenants can be in different circumstances, but both be able to take advantage of the COVID-19 protections. But all tenants would be covered. Just one last thing, the master tenant typically is the only one that the landlord will interact with. So sometimes that is the person that will actually have to take the action based on what the subtenants are telling them.
All right. So this is a 2-part question. One, is Ellis Act something that would be applicable if a building is sold? And what is the definition of disabled for Ellis Act?
So yes, when a building is being sold, is one of the many things you should be cautious about is this going to be a developer, speculator, flipper that's going to buy the building, send out an Ellis Act eviction the day after it clears escrow with the hope of turning it in, for instance, a 2-unit building, turning it into tenants in common, or turning it into having 2 landlords move in or 2 owners move in. We have a moratorium right now on condo conversions, but 2-unit buildings are exempt if each unit has had a landlord, or an owner, I should say, of at least 25% of record living in it for a year. So 2-unit buildings are pretty easy to bypass, obviously, the moratorium. So anytime the building's being sold, there's a good chance in San Francisco that a speculator will be looking at it. And I'm sorry, what was the second part?
What constitutes, what's the definition of disabled for Ellis Act?
So disabled depends on whether it's the absolute prohibition against evicting someone or whether it's just the relocation payments. If you're on SSI, that is the more, say, stringent amount that could actually stop an Ellis Act from going forward. If you have a disability under California law's got a very loose definition of disabled. California says if your blood pressure's perfectly, 110/60, but you're taking medication, you're a disabled person in California's eyes. If you're taking insulin or some medication to keep your blood sugar levels regulated, California law says that you're disabled. Same thing if you're taking antidepressant and your moods are perfect. California law says if you take away that mitigating measure, would you have issues? If you do, then you're disabled. So to get the relocation payments, it's pretty easy to qualify for those extra legal relocation payments.
Okay, cool. Do emails or texts count as writing, or does it need to be a sent letter?
So it sort of depends on the circumstances, but they do count. But, the law and technology are not exactly running parallel. So if you normally communicate with your landlord by text or email, yes, as long as you can save those and they don't get wiped out and you can actually prove that they occurred. The problem comes in if a landlord gets an email that they're not too thrilled to get, and then they don't acknowledge it, they don't reply back. Can you do forensics on a computer to prove that the landlord got that email? Well, yeah, but that's probably not going to be the case in most cases. So if you're going to write an email that's very important to the landlord to acknowledge it, I always say try to throw in a question that you think they might answer so that you have proof that they got it. Now, when it comes to terminating your tenancy, like giving your 30-day notice to leave and certain other items, you can go ahead and send the email or the text, but we would recommend that you follow it up with the snail mail, with a proof of mailing or certified.
Right. Okay. Another question. Is there a format sample letter that tenants can use? Does the tenants union have any template letters?
A template letter for, I'm sorry.
They didn't actually specify.
Okay. So we do have a couple of, if in our handbook, we do have some sample letters in there. And for instance, if you're asking for your deposit back, that's one, because tons of those. So we do have sample letters about asking for your deposit back. That would be one. And then the other thing that's a very important template that we have is when the landlord tries to change the terms of your tenancy. Landlords aren't allowed to make unilateral changes in the terms of your tenancy. But if they send you something saying, I've decided that you can no longer park there, I'm going to take away your garage, you can't put storage there, you got to get rid of that pet that you have permission for, you have to always push back and in writing write something that's saying, I refuse and reject your change in terms. Being silent can be perceived as being in agreement. So there's certain times you absolutely must write back, and that template that we've got allows you to push back on any kind of change in terms.
Cool. Cool. All right. This question says, I am a subtenant and the master tenant tried to menace me into moving when rent shot up. I didn't, and I'm still there. He doesn't talk to me, shut off my internet, and has been thrashing the apartment. Do I have any course?
Okay, so you're being harassed, obviously, and I think that to get into the details of exactly what you need to do to, first of all, what I said earlier, make sure above all things that you're keeping as much documentation on what's happening as possible. Keep that journal, things that were said, things that happened. Most importantly, if there's any chance that you feel that this is escalated or is about to escalate to physical altercation, or that you could be harmed, be very cautious. So that's the sort of thing that you should definitely make an appointment to talk to a counselor and get the details and get them to proceed about the best there are conflict intervention services. For example, the rent ordinance has a free service that they will mediate disputes between tenants. If the adversarial tenant is willing to go, it is a voluntary thing though. So if that person is not willing to go, then mediation might not work. But we often recommend mediation first in these situations.
Great. Okay, and another one is a neighbor neighbor harassment, and how can the landlord provide assistance, if any?
So I'm going to assume that that's not, is that a, we'll talk it two ways. So if it's a neighbor in your building and one of your one of the other apartments in the building is harassing you, your landlord will probably say, I can't do anything about this. It's not my problem. That's simply not true. Everyone is entitled to the quiet enjoyment of their premises. That's an implied right. It doesn't have to be written into your contract. So if someone is very dramatically interfering with the quiet enjoyment of your premises, and you've tried to, mediation, talking with them, whatever doesn't work out, it may be necessary for your landlord to get involved. And even though they may say it's not their problem, it is, because they have an obligation to take whatever measures they can to make sure that you do have the quiet enjoyment of your premises. Now, if this is a neighbor next door, that's something you should talk to a counselor about, because that's really getting out of that's no longer in the realm of landlord tenant.
All right. And then this is the last question I have, but folks, if you have any other questions, please just put them in the chat. This question says, I was offered a buyout a year ago. Does that ever expire?
Well, buyouts are a privately negotiated scenario, and if your landlord was interested a year ago, they might still be interested. There is a certain amount of disclosure that does have to take place with these, even though they're privately negotiated. So the most important thing I can tell you about buyouts is make sure that the landlord follows the procedure. So you should first, before the landlord even mentions, are you interested in a buyout, you should get paperwork that's from the rent board that says your landlord's interested in discussing this with you. And you can either choose to engage with them, or you could choose not to engage with them. So I don't know why this didn't go forward, or if it died out, or the negotiation stopped. But you're only if you do agree to negotiate with the landlord, that's all you're agreeing to. You're only agreeing to listen to what they have to say. And then if you choose not to be interested, then you can just walk away. We got the legislation changed because people used to sign things because it would sound like an awful lot of money, more money than maybe you'd ever had in the bank before. And then after you had time to think about it, you realized, oh, you're totally messed up, because you're never going to be able to stay in San Francisco when that money's gone. So even if you do have a moment where you don't think clearly and you sign that agreement, you've got 45 days to rescind it. But as far as if your landlord was interested in a buyout before, it sort of depends on the nature of what's going on in the apartment. And that's something you might want to talk to a counselor about, because there might be some other strategies involved, and it sort of depends on the individual circumstances.
Okay, great. Okay, so another question just came in. I've been paying my rent, but I don't know if the master tenant is paying to the landlord. What can I do if he, and I'm assuming this is the master tenant, just takes my rent money and splits?
So the most important thing is that you saw throughout this presentation is get it in writing, get it in writing, get it in writing. So first of all, protect yourself by making sure that, because we see this often among tenants, that sometimes there's cash exchanged and maybe you get along with the person at the time and then later on you don't have a receipt when they get crosswise with you. So if you're going to be paying the master tenant, it's very important that you get a receipt, keep good records when you paid, etc. Now, the owner landlord is probably not going to interact with you most of the time if you're a subtenant. So you probably will not be able to go to the owner landlord for the most part, but the master tenant did have an absolute obligation to disclose to you at the beginning of your tenancy how much they paid. And so they might, to go along with this, they might not be paying all of it, and they might be paying even less than you think they're paying. So rent gouging is not allowed. Master tenants can't charge a disproportionate amount to their subtenants. But if that master tenant, for example, we're seeing some of this lately, where the master tenant's not paying because they've lost their job or they're having decreased income and they don't know about these provisions, it might be to your benefit to encourage your master tenant to seek counseling, because if that's the reason they're not paying, that can be fixed.
Yeah.
But you should definitely talk to a counselor if you cannot extract enough information from them and get some more deep strategies.
Yeah, good idea. The follow-up question was, I pay with check. Is that okay for proof?
Absolutely. It's any kind of written instrument that you can prove that the landlord did receive it. Because people sometimes change banks and sometimes people can live in their tenancy for decades. What I would say was those rent checks, you might shred a lot of other things, but you might want to keep those in a file. And if not, keep a record from your bank that shows all those payments, do like a summary at the end of the year. And so if you keep good records, yes, those checks are definitely considered proof. The other thing is that I didn't mention early on is that now that we're in this position where a lot of people are not paying rent some months and some months they're not, it's very important that you always write on that check what month and what year rent you're paying, because landlords have the option to, or not during COVID-19 Relief Act, but in the future, they have the right to apply any money you give them to the oldest debt unless you specify what it's for. So there is provisions in the new law that they're not allowed to do that, but it's a good rule of thumb to know what, to make note what exactly you're paying for.
Right, cool. All right. So yeah, we have about 7 minutes left. If anyone has any other questions, please post them in the chat. We do have we have a panel discussion tonight at 7 about eviction protections during COVID. That'll be in English, Spanish, and Chinese. So if you're interested in that, please, I just posted the link to that one tonight. Let's see if there are any other questions. One question, how did this subtenant category come to be? That might be a long, a long answer.
Okay, well, so that this is a time that we can tell you a little bit about the different categories of tenants.
Yeah.
So there's an original tenant and there's a subsequent tenant. The original tenant is the person who's been there from the first day the tenancy was occupied. To be an original occupant, you can even be a child. You can't be a tenant because you weren't old enough to enter into a legal agreement, but a child who moved in with their parent 30 years ago is actually an original tenant and actually retains the rent control as long as they never leave that tenancy, even if their parents leave. Subsequent tenants are tenants who come in later. So original tenant can either be someone whose name's on the lease or someone who's there from the beginning. Subsequent tenants are anyone who comes in after that original tenancy. Subtenants are tenants who do not have a financial relationship directly with the landlord. tenants often run into this where they try to interact with the landlord or give the landlord a check. That means you've never given the landlord a check. The landlord doesn't, you call them for repairs and they might say, no, have the master tenant call me. Subtenants obviously don't have the same rights that full tenants do. Now, two tenants that move in the same day and sign the lease are co-tenants. And you can have a co-tenant added later on as a subsequent co-tenant. And that's, co-tenants means everybody's on equal grounds. You got the same rights. You can't evict each other. And co-tenants have a direct relationship with the landlord, either come from their name on the lease or for giving him checks or interacting with him. Subtenants are a way for the Costa-Hawkins Act to raise rent when the original tenant leaves. So if you can ever elevate yourself from a subtenant to a co-tenant, you're going to protect yourself from Costa-Hawkins.
Great. Okay, and then a really important question. I would like to speak to a counselor. How can I get connected?
So I don't know if there's a, I know that there's a link on the page for the expo to get counseling, and you can fill out a form. I don't know. Do you know how to tell them how to get to that from here? I do not know.
I will drop the link in the chat.
Okay.
Is that on the, so we have the page for the SF Tenants Union. So I'm putting that on there.
Yeah, well, there's a link to the, what they call it, sorry, I'm just blanked out, the help desk, not help desk, the help center or something.
Yeah.
So there's a thing on there and it says, fill out this form and you fill out your name, phone number, and the general idea of why you're calling. And we'll be counseling up until 8 p.m. tonight.
All right, and I'm putting that link in right now. This is our help center that's going on.
And by the way, for anyone out there, it's blocking, some of these are going to be from block numbers. So if you see a block call come in, you might want to go ahead and answer. We'll identify ourselves quickly so that you know it's not a scammer.
All right, so if you sign up, please answer those block calls. So in the chat, I just put the link for how to get connected right now. So you can actually go to our live help center from the expo and get connected right now. Okay, so one last question. I think during these COVID times, I signed up for the rent deferral program since I'm not working. The application was given to me by my apartment manager. Then a few days later, he asked me, how much can I pay monthly and when will I start paying? To me, that was a bit too soon of a question since I just signed up for it.
Okay, so I'm not quite sure what you mean by rent deferral program. Some landlords have tried to get tenants to sign these agreements about the payment of their rent. That's very different than the protections that are built in. So I'm not quite sure. I think that you definitely need to talk to a counselor because there should be ability to only pay 25% as long as you follow the rules that we mentioned earlier. And as long as you meet that 25% by June 30th, you can never be evicted. And there's rental relief coming. So hopefully you'll have all your debt, depending on it's going to be pretty much the people that are 50% area median income. If you're below 50% area median income, you're going to be in the first tier of that money. And it's going to be offered to your landlord, and they're going to say, we'll give you 80%. Let's say you owe the landlord $40,000. They'll say, well, landlord will give you $32,000, but you have to forgive the tenant's debt completely. Doesn't go on your record. And this law doesn't allow this to go on your record anyway, but it wipes out that debt completely. So you definitely want to talk to a counselor about getting protected by this particular law.
All right. Yeah, so head over to that help center on the link I just put in the chat and get connected for sure. All right. Well, I think that's about our time. But thank you so much for everyone that came. Thank you, Layla, so much for all this really important information. Thanks to the San Francisco Tenants Union. And thank you so much for coming.
Yes, thank you, everyone. Thank you.